Good afternoon, my dear students. Welcome to online recording classes due to COVID-19. So, in part of the company law subject, in last session, we have discussed about the characteristics and advantages and disadvantages of the companies. So, when incorporated company, how the companies are registered means as per the Companies Act 1956 and 2013. 1956 is the old and 2013 is the new. So, after coming to the point, then lifting the corporate wealth. So, one of the fundamental principle of the company law is that a company has personality that is distinct from that of its shareholders. So once a company is formed and registered under the Act, so it is a separate legal entity, that's already known. So distinct from its members. So it can show and be showed in its own name, and this rule was laid down by the House of Lords in Solomons and Solomon Company in 1897, in which it was held that even if one individual held almost all the shares and debentures in a company, but and if the remaining shares were held on trust for him, the company is not be regarded as a mere shadow of that individuals. So that's why the principle of separate entity is regarded as a curtain and a veil or shield between for the company's its members, and sometimes thus protecting the latter from the liability of the former, and the veil is impassable as an iron curtain. So the concept of the corporate entity was evolved to encourage and promote trade and commerce, but not to commit illegal, illegalities or to defraud people, and circumstances may occur which compel the court to identify a company with its members. So that's why when the notion of legal entity is used to defeat public convenience, so justify wrong, protect fraud, and deferred crime, the law will not regard the company as a corporate entity. So, what is the lifting the corporate wealth? So, then the lifting corporate wealth means in reality, the business of the artificial person is always carried on for the benefit of some individuals. So, since an artificial person is not capable of doing anything illegal or fraudulent, so the notion of corporate personality might have to be abandoned to identify the person who are really guilty. So this is known as lifting the corporate wealth. So the concept of lifting the corporate wealth is a changing concept. It is the changing concept. So that's why it can be lifted for the benefit of the company too. So the circumstances under the courts may lift the corporate wealth may be discussed under the two situations and two heads. One is common law exceptions and statutory exceptions. So what is common law exceptions under lifting the corporate? Lifting the corporate wealth. Okay. So, once again, in reality, the business of the artificial person is always carried on for the benefit of some individuals. So, since the artificial person is not capable of doing anything illegal or fraudulent, so the notion of corporate personality might have to be abandoned to identify the person who are really guilty. It is known as lifting the corporate wealth. So, the circumstances under this, which the courts may lift the corporate wealth, may be discussed under the following two heads: common law exception, common law exception, and statutory exception. So what is common law exception? It is very difficult to enumerate all the cases in which courts have lifted or might lift the will. So the corporate will has been lifted the priced by the courts for the following cases. So that is the determination of the character under common law exceptions. Common law exceptions. So first one is the determination of character. Determination of character. How a company is not a natural person. So with mind or conscience, and but it may assume when persons in effective control of its affair and residents in any enemy country, okay, or wherever residents are acting under the direction and control of the enemies. So in times of war, the court will lift the well to see whether a company is controlled by enemy alliance. Consequently, a company registered in England may be allied enemy if its agents are the persons in defective control of its affair or ally. So that's why the determination of character is very, very important. A company is not a natural person. Okay. And second, where companies is shared. Company is a share. So the court will lift the bill where the company is a mere clock or shape, that is, where the device of incorporation is used for some illegal or improper purpose. Okay, illegal and improper purpose, that is the main headline. Where a person borrowed money from a company and invested in the three different companies, in all which he and his son were the only members. But the lending company was permitted to attach the assets of all the three companies as they were created to hoodwink the lending companies. So that is fraudulent. How the court is going? So when will share? If any of the family members are introducing as a members, other members are not there. Next, prevention of fraud or improper conduct. Prevention of fraud. Fraud or improper conduct. Improper conduct. So, where it appears that the company was incorporated for evading contractual and statutory obligations, the court may disregard the separate existence of the company. So that's why sometimes the court held the company was a mere proclaim the purpose of enabling the defendant the committee in breach of his agreement against the socialization. So that's why the facts compulsory you have to identify. So when prevention of the fraud and improper conduct, and fourth one, where the company is acting as an agent, of the shareholders. Means when a company is acting as an agent of its shareholders or of another company, it will be liable for its acts. So, however, it is a question of fact in which case whether the company is acting as agent for its shareholders always. Why? Because in business entity concept, what is there? The business is different, firm is different, and the contributors are different. So that's why the company is acting as an agent. So, this question has frequently arisen in connection with the government companies in India. A government company is not an agent of the state unless it is performing substantial governmental or surveillance functions. Next, protection of revenue. Who protect? Protection of revenue. Protection of revenue. So the courts may disregard the corporate entity of the company where it's used for tax evasion or to circumvent tax obligations. So that's why courts will price the corporate wealth if the device of the company is used to avoid tax liability. So in central excise, an assessee entitled to SSA exemption of his turnover is below exception limit, that is. However, at times two companies are formed only for name's sake to ensure that each company is below excessive exception limits. Next, avoidance of welfare legislation. Avoidance of welfare legislation means here. So the avoidance of welfare legislation is an common as the avoidance of the taxation. So it is the duty of the court in which in such cases to get behind the smoke screen and discover the true state of affairs. Next, punishment of contempt of court. Punishment of contempt of court. So, person responsible for the contempt of court can be punished. If contempt of court is done by a company, courts can find real offender by lifting the corporate bill. So, ascertaining true nature. True nature of transaction. If alleged as shame, alleged as shame. So, court will be justified in lifting the corporate wealth to ascertain the true nature of transaction as to who are the real parties to sale and whether it is genuine and bona fide. So this is very important. Determination of the technical competence of company. Determination of technical competence of company. So, the Supreme Court in a recent decision had delivered an interesting and very significant judgment. So, with regard to lifting a corporate wealth, the court held that the experience of the promoters and directors is the experience of the company. So, promoters means, so before registration, who are gathered to install a company, the persons are called as promoters. Directors means after registration, after collection of the capital and after contributing the amount by the public, so the director elected from the who are contributing in the company. Then the facts as the case a new company was formed as joint venture by the other companies for the purpose of the applying for a telecom tender. So the company was new and had no experience in this field. However, its promoters had vast experience in the telecom field. So the tender evaluation committee rejected the tender on the ground that the company has no experience in the field. So the Supreme Court observed that in respect of such a joint venture, the experience of the company would include the experience of the constituents of the joint venture as well. So that is a new case determination technical components of the company. అంటే ఎక్స్పీరియన్స్ ఉందా లేదా బట్ హూ విల్ డూ హూ ఆర్ డూయింగ్ సో హూ ఆర్ ది ఎక్స్పీరియన్స్ పర్సన్ వెన్ ఇన్స్టాలింగ్ ది కంపెనీ సో దట్ కంపల్సరీ విల్ సీ నెక్స్ట్ ఫార్మేషన్ ఆఫ్ సబ్సిడరీ కంపెనీ ఫార్మేషన్ ఆఫ్ subsidiary company to act as an agent. So the company concept of lifting the corporate wealth is a changing concept. So it can be limited for the benefit of the company too. The Supreme Court in one of its recent decisions held that where the holding company hold 100% of the shares in a subsidiary company and the latter is created only for the purpose of the holding company. So the corporate wealth can be limited. So according to that, according to Companies Act, according to the sections, okay, so these changes as per common law exception. So that is lifting the corporate wealth when. So the new amendments are there as per the 2000 Companies Act 2013. So according to that rules, they are doing determination of the character and where companies a share and prevention of the fraud and improper conduct and when the company is acting as an agent of the shareholders, okay, and protection of the revenue and avoidance of welfare legislation and punishment of the contempt of court, then contempt of court and ascertaining the nature of transactions it alleged as share and the determination of the technical competence of the company and formation of subsidiary company to act as an agent. Next, statutory exemptions. So these are the common exemptions. Next, statutory exemption. So what is statutory according to Act? The Act disregards the separate existence of the company in certain cases to check the misuse of the corporate personality by directors or members of the company. So in other words, the benefit of separate entity and limited liability may not be allowed to be enjoyed in certain circumstances. So that is misstatements in prospectus. Statements in prospectus. So that is section 34 and 35. Here the misstatement in prospectus means when collection of the capital after registration of the company and after register of the capital, the public companies are issuing prospectus to the public. So if any misstatement is there in prospectus, inviting the shares, prospectus means inviting the shares. So the total information is available in prospectus. So a person who has sustained any loss or damage as a consequence of misstatement in prospectus, the company and every person who is a director of the company at the time of the issue of the prospectus and has authorized himself to be named and is named in the prospectus as a director of the company, or has agreed to become such director either immediately or after interval of the time, and is a promoter of the company and has authorized the issue of the prospectus and is an expert transferred to section 26 subsection 5. So he is liable to pay compensation to every person who has sustained such losses or damage as per section 35. Okay. When a person who has sustained any loss or damage as a consequence of misstatement in prospectus, so that's why he is a director of the company at the time of the issue of the prospectus. One is Muslim. So, is there any misstatement in prospectus? That is the one statutory exception. Second, misdescription of company's name. Description of companies. So the section is section 12. So according to section 12 Companies Act, according to section 12 of the Companies Act 2013, every company should have its name printed on hundies and promissory notes, bills of exchange, and such other documents as may be prescribed. So if any default is made in complying with the requirements of this section, so the company and every officer who is in default shall be liable to a penalty of 1,000 rupees for every day during which the default continues but not exceeding 1 lakh rupees. Okay. So per day 1,000 rupees, but it will not exceed 1 lakh. So when the misdescription of the company's name, who are, so sometimes not printed on that, what they are asking, what they require. So that's why the shall have its name printed on hundies, on promissory notes, on bills of exchange, and such other documents as may be prescribed. But if any default is made in complying with the requirements of this section, the company and every officer who is in default shall be liable to a penalty of 1,000 rupees for every day, during which the default continues but not exceeding 1 lakh rupees. So the directors were held personally liable on a check signed by them in the name of the company, stating the company's name. Right. So whatever it is, what name is there, you have to print. Next, failure to refund application money. Failure. So refund application money, when a company issues shares to the public, the minimum subscription as stated in the prospectus has not been received within 30 days of the issue of prospectus. So such other period as may be prescribed by the SEBI, the application shall be refunded within a period of 15 days from the closure of issue. So where such money is not refunded within such period, the directors and officers of the company in a default shall be jointly or severally liable to repay that money with the interest at the rate of 15% per annum. In case of default, the company and its officers who are in default shall be liable to a penalty of 1,000 rupees for each day during which such default continues to a maximum of 1 lakh. Again. So the company issued the prospectus inviting the applications from the public. So it is within a stipulated time, that is within 30 days. So sometimes within 30 days the minimum subscription not received from the public, okay, then after within 15 days you have to refund to public. So if not refunded to the public because the minimum subscription is not received, so who contributed? Okay, so that amount is less. That amount you have to pay within 15 days. Okay, after minimum subscription is not received. So if any misuse where such money is not refunded within such period, then immediately the directors and officers may be default shall be jointly or severally liable to repay that money with interest, that is at the rate of 15% per annum. And in case of default, the company and its officer who are in default shall be liable to penalty of 1,000 rupees for each day during which such default continues to the maximum 1 lakh. Okay, ఇవ్వలేని పరిస్థితిలో 1,000 rupees fine వేస్తుంది. So maximum 1 lakh rupees. Investigation of ownership of company. Investigation. Ownership of Section 216. So Section 216 empowers the central government to appoint one or more inspectors to investigate and report on matters relating to the company and its members for the purpose of determining the true persons. So who are having the financially interested in such success or failure, whether real or apparent, of the company, and who have been able to control or to materially influence the policy of the company. So very clear, investigation of the ownership of company. Ever start chesaru? So who are the responsible person when starting the company? So that information is very important. So the central government will appoint one or two persons, one or two inspectors to investigate and report on matters relating to the company. అది ఏ కంపెనీకి సంబంధించింది ఆ కంపెనీ యొక్క ఇన్ఫర్మేషన్ వాళ్ళు రాసేస్తారు. నెక్స్ట్ ఫ్రాడులెంట్ కండక్ట్. Fraudulent conduct. Section 339. So according to section 339, wherein the course of the winding up a company, it appears that any business of the company has been carried on which intent to defraud creditors of the company or any other persons or for any fraudulent purpose. So the tribunal on the application of the official liquidator or the company liquidator or any creditor or contributor of the company may, if it thinks too proper so to do, declare that any person who is or has been a director, manager or officer of the company or any persons who are knowingly parties to the carrying on the business in the manner of foresight, so shall be personally responsible without any limitation of the liability and for all or any of the debts or the other liabilities of the company as the tribunal may direct. So every person who was knowingly a party to the carrying of business in the manner as stated above, so shall be punishable with imprisonment for term which may be extended to years or with fine and also which may be extended to 50,000 rupees or with both, whatever it is. So fraudulent conduct if any, then in course of the winding up of a company, it appears that any business of the company has been carried on with intent or default creditors. So whatever it is. So these points you have to note it when the statutory exemptions lifting the corporate wealth, misstatements in the prospectus, misdescription of company's name, and failure to refund application money, and investigation of ownership of company and fraudulent conduct. So liability for ultra virus acts. Liability for ultra virus ultra-virus acts. So every director officer of the company then will be personally liable for all those acts which they have done on behalf of the company if the same are ultra-virus of the company. So whatever, it's a very important topic. Today we have discussed about lifting the corporate wealth. So according to that, it's a new concept in the company according to the Companies Act 2013. So the concept of lifting the corporate wealth is a changing concept. So that's why it can be lifted for the benefit of the companies too. So that's why the circumstances on the which courts may be lift the corporate wealth may be discussed under the two following heads. One is common law exception and statutory exceptions. So under common law, some points are given, and under the statutory exemptions, 6 points are we have discussed. So thank you very much. Have a nice day. Next, we will discuss about the classification of the companies. Thank you.